Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. For today's stream, we turn our attention to Gina Carano. Gina Carano is an actress who was working on The Mandalorian, a Disney project, which she was having some problems on because of some issues relating to some social media that she was doing. And she was fired by Disney for the social media messages, which was, going questionably. Anyways, she was fired for the social media messages, and she's suing basically for breach of contract in so many words. Disney is saying, wait, we've disaffiliated ourselves because we don't like her messages. We have a First Amendment interest in this. So this basically comes down to contract law. This comes down to the contract she signed and, of course, any operative state level proceedings that might exist relating to this, but principally contract law. So we're going to do that. We are in the Central District of California, and we are going to read the court order denying the motion to dismiss. So this case was filed back in February. So about 6 months later, we are allowed to go forward. So she made it past the initial dismissal. So that's pretty nice. Cool. We're going to read this and try to understand the court's reading. Let's go along with this. Before the court is the defendant, Walt Disney, Lucasfilm, and Huckleberry Industries, and together with Disney and Lucasfilm, the motion to dismiss for failure to state a claim. Having considered the submission's oral argument relevant law on the record, the court denies. Thus, let's go over the facts. This case arises from plaintiff Gina Carano's termination from the Disney show The Mandalorian due to posts she made on various social media platforms, including X, formerly known as Twitter, and Instagram. Defendants chose plaintiff to play a character named Cara Dune in the Star Wars series and employ her effective as of September the 18th of 2018. On February the 10th of 2021, however, defendant abruptly terminated plaintiff's employment after she reposted content created by another social media user. This lawsuit followed. Okay, so she's making some posts on the social media. Disney does not approve of what she's saying. Disney fires her. The question is contract, right? Because they hired her to do a thing. What is her flexibility? What is their flexibility to fire her? Do they have to pay her off? That kind of issue. Great. After hiring plaintiff, the defendants prominently featured her in promotional materials for the show. Plaintiff contract for the first season designated her as a guest actor entitled to a minimum salary of $25,000 per episode in which she appeared. Given the popularity of the character, plaintiff's agent sought to increase her pay for the second season, but defendant refused, offering her a one-time bonus of $5,000 and the same $25,000 per episode minimum salary. Okay. During the summer of 2020, plaintiff began receiving frequent messages on social media to support various causes, adopt various ideologies, and hold herself out in various ways, according to the complaint. In particular, social media users urged plaintiff to publicly support the Black Lives Matter movement, including by endorsing certain slogans associated with that movement, and to indicate her preferred pronouns in her social media profile. When plaintiff did not do so, members of the public accused her of being a racist and leveled various epithets at her, including on one social media user who called her a transphobic biatch, which of course is what they do. If you disagree with them, they're going to make names of you, make fun of you, and make names, right? If you disagree with them, they'll call you a Nazi, they'll call you a fascist, they'll call you a racist, they'll call you a sexist, they'll call you a transphobe, any of these labels, because that's what they do. Because then once they label you, they don't have to take you seriously or consider your ideas in any way. So, yep, that is pretty much per normal. No big surprise there. Although one of plaintiff's castmates supported her on social media, defendants did not intervene. On September the 5th of 2020, plaintiff criticized certain COOF policies, requiring businesses and churches to remain closed while allowing public protests, because that's a little bit odd. That's a little odd, right? If we're going to say, right, this is all about consistency of ideas. This is where the problem comes from, is the inconsistency. It's like, okay, this is a dangerous disease and people shouldn't be allowed to gather. Okay, but people should be allowed to gather in large numbers in order to protest things. But only the things that we want them to protest. See, that doesn't really make sense. It doesn't flow. And so you're pointing out an inconsistency in a supposed ideology, or an inconsistency in a supposed belief. Yeah. Plaintiff alleges that she was attacked for these views, and defendant made known their disapproval of plaintiff's position. 1 week later, on September the 12th of 2020, frustrated by social media users' continual comments, and critiques regarding her choice to not include her preferred pronouns in her Twitter biography, plaintiff put the words boop, boop, bop, beep in her profile, referencing the sounds a droid would make. I'm here for it. I'm here for it. Plaintiff deleted this material a short time later after originally posting it and sharing that she had spoken with her castmate, Pedro Pascal, about why other individuals listed their pronouns in their biographies. At some point in time, defendant began demanding an explanation from plaintiff and criticizing her for not embracing social media users' demand that she list her pronouns. Defendants engaged plaintiff in long phone calls, constant meetings, and what plaintiff referred to as re-educational programs. Again, this is all from her complaint. We are assuming the truth of her complaint for the purposes of this discussion, which we always do, right? The question is, given everything they say, is there a claim here? So the court isn't saying these things are true. The court is simply saying we're going to assume them true. We're assuming everything she says, at least as far as the facts go, are true, right? We assume her facts. We don't have to assume her conclusions, not particularly conclusions of law, but we do have to assume her facts. So did the meetings occur for the purpose of this discussion? Yes. Did defendant say certain things to her for the purposes of the discussion? Yes, right? Because those are questions of fact, right? They aren't conclusions. These are things that allegedly happened, and we're going to assume them because that's what we do in a motion to dismiss. Okay. As part of the communications, defendant required plaintiff to meet with representatives of the Gay and Lesbian Alliance Against Discrimination. Plaintiff did so gladly, reviewing several documentaries that representatives asked plaintiffs to watch, and the representative posted positive feedback to defendants. Not satisfied, however, defendant continued to demand that plaintiff issue a public apology, including by asking plaintiff's publicist to force plaintiff to issue a statement admitted to mocking or insulting an entire group of people. I guess they didn't appreciate the beep, boop, bop pronoun choices. Plaintiff's refusal to issue the proposed public statement, and defendants rejected an alternative proposal. Plaintiff alleges defendant increased their harassment of her at this point. Interest in showing good faith, plaintiff sought to donate to a GoFundMe page purportedly created to support the transgender community. Okay. Upon visiting the website, however, she read the page had apparently been created by Lucasfilm employees and described the plaintiff as a bigoted actress. Again, just with the name calling, right? You disagree, you're a bigot, you're a transphobe, you're a sexist, you're a racist, you're a fascist, you're whatever label they want to throw your way because you don't agree with their claims. You don't agree that certain things are true. And so they'll just label you things. Yep. I know it all too well. It does happen even here on civil law. It's like, and it's just like you guys got to roll with it, I guess. When plaintiff brought the website to their attention, Lucasfilm denied any of its employees had created the account. Shortly thereafter, the page was altered instead to describe plaintiff as ignorant, and its organizer was no longer identified as a Lucasfilm employee. To plaintiff's knowledge, no Lucasfilm employee was ever disciplined for this conduct. Defendant informed plaintiff's publicist that they would require plaintiff to participate in a video conference with Lucasfilms with Kathleen Kennedy. So yeah, we're going to keep having the meetings until you change your mind. The beatings will continue until morale improves. 45 of defendant's employees also were to attend the meeting, who would identify as the LGBTQ !@ community as a litmus test. Although several of the employees had contributed to the above-mentioned GoFundMe account, defendants encouraged plaintiff's publicist to describe them as a friendly group. Plaintiff alleged that in defendant's views, she had grown and learn. Until defendants knew where her mindset was currently regarding pronouns, defendant would not allow her to speak to the media and would not include her in promotional materials. The plaintiff declined the proposed meeting, but offered to take a smaller group of 5 or 6 employees to dinner for a face-to-face discussion, a counteroffer to which the defendants did not agree. After plaintiff suggested that she might need legal assistance to resolve the dispute, defendant instead required to undergo media training. Plaintiff also faced backlash over statements she made on social media regarding the 2020 election. As an example, plaintiff's complaint included a November 5, 2020 social media post in which plaintiff stated that we need to clean up the election process and call for laws that protect us against voter fraud, as well as for voter identification requirements. Well, you can't say those kinds of things. Those are the wrong thing, ma'am. Plaintiff alleges that instead of defending her, defendants expressed dismay that plaintiff's political views did not match what they expected from their stars. All the while, plaintiff continued to promote The Mandalorian. And by early 2020, she's responsible for over half of talent engagement on social media relating to the show's second season. On November 21st, 2020, after plaintiff made her first appearance on the second season, Lucasfilm employee Lynn Hale emailed plaintiff to congratulate her on the success. Around that time, in October or November of 2020, The Mandalorian's creator and executive producer, Jon Favreau, told plaintiff that their life was about to change. Defendant had approved a spin-off of the series to be entitled Rangers of the New Republic, and plaintiff would be one of the lead characters. As a lead character, plaintiff would have been a series regular. Series regulars in other Star Wars spin-offs received long-term contracts with compensation beginning at $150,000 to $250,000 per episode, a substantial increase. Yes, that would be about 10 times as much. That would definitely, that's 8 times to 10. No, that would be 6 times to 8 times, or 6 times to 10 times as much. So yes, that would definitely get my attention. Fairview also represented the plaintiff would participate in a series of Star Wars movies based off of the Disney shows, including The Mandalorian. In December 2020, Kennedy confirmed the production of the Rangers of the New Republic spin-off series at Disney Investor Day. Fun. On January the 8th of 2021, Hale inadvertently sent plaintiff an internal email containing plaintiff's defendant's discussions of a hashtag calling on Disney to fire Gina Carano, social media activity to which defendant monitored. The email thread first pertained to backlash to the statement that Disney's chief executive officer, Bob Chapek, made after a January 6, 2021 insurrection. Much of the criticism concerned Disney's business with China, but certain members of the public also called on Disney to fire plaintiff. In the email thread, Disney quickly focused on plaintiff rather than its business dealings in China and began preparing a report on plaintiff. Plaintiff alleges that Chapek intended to use Carano to deflect attention from the failed leadership of Disney. On January the 12th of 2021, plaintiff posted an interview in which she discussed controversy concerning her social media activity. Around the same time of January 2021, the official Star Wars Twitter account issued a statement of support for another employee who faced criticism for certain statements that she made regarding racism. So Disney is certainly willing to back certain viewpoints and not other viewpoints, which is probably far enough as fair as it goes under just general First Amendment principles. But then, of course, we get into contractual issues that may or may not exist. So we'll see. On February the 10th of 2021, plaintiffs shared a social media post that questioned the difference between those who hated someone for their political views and citizens in Nazi Germany who hated their neighbors simply for being Jewish. See, you aren't allowed to make a Nazi comparison. Only the left-leaning people are allowed to make Nazi comparisons, don't you know? So if you're making a Nazi comparison to criticize the left, you're an incredibly bad person because you bring the Nazis into it. But if you're a left-leaning person who makes a Nazi comparison, you're a hero. You're a star. So her Nazi comparison is very, very bad. The left-leaning Nazi comparison is very, very good. Apparently, I guess. As relevant to these actions, plaintiff's castmate, Carl Weathers, had previously shared similar messages on social media, although plaintiff alleges that his posts were interpreted to attack Republicans and accordingly acceptable. Yes, sometimes comparing people to Nazis is okay, sometimes not. Depends whether or not you're in overall support of the message. If you're in overall support of the message, then basically anything you say is okay. And if not, then we'll criticize you for it. That's how that seems to go. Additionally, Pascal, who plays the titular character in The Mandalorian, previously made statements on social media comparing former President Donald Trump, his administration, and supporters of Nazis. Wow, that's the first time I've ever heard of anything like that. Donald Trump being compared to a Nazi? Man, oh man, never seen anyone do that before. Disney must be shocked. Pascal also posted an image of Disney-owned Muppet characters with a pride flag and the message Black Trans Lives Matter and defund the police. Defendants did not comment on any of these posts, nor did they discipline Pascal, require him to view documentaries, or attend meetings with individuals with contrary points of view, pressure him to apologize for these posts, or refer to his social media activity as abhorrent. Similarly, Star Wars actor Mark Hamill made various statements on social media, drawing similarities between the Republican Party under Trump and the Nazis, without objection from defendant. Indeed, Hamill made a guest appearance during the final episode of The Mandalorian second season. In response to plaintiff's post, however, defendant terminated plaintiff that day. Defendant released a statement characterizing her post as abhorrent and unacceptable because they denigrated people based on cultural and religious identities. Yeah, okay, sure. Which is different than what the left does, but it's the wrong thing. It's the wrong thing. Yep. Chapek further explained defendant fired plaintiff because she didn't align with company values. Defendant also canceled production of the Rangers of the New Republic series. After her termination and defendant's statement, members of the media as well as stalkers came to plaintiff's home, causing her to fear for her personal safety. Plaintiff also alleges that defendant engaged in a smear campaign against her following her termination. For example, in November 2020, plaintiff filmed an episode of Running Wild with Bear Grylls, a show that aired on Disney's own Nat Geo. After terminating plaintiff's employment, Disney removed this episode from the Running Wild lineup. After protests from fans and intervention by Bear Grylls, Disney reversed the decision but removed plaintiff's name and likeness from the promotional materials as well as from the episode listing. Following her termination from The Mandalorian and defendant's statement, plaintiff's agent and entertainment attorneys both dropped her as a client without explanation. Yep, that's what happens, right? That's what happens. You're on the wrong side of the wrong thing, and everyone wants to back the mouse. That's encouraging. That's encouraging. Plaintiff also immediately stopped receiving invitations to read for new movies, attend high-profile events, and promote her work. Cool. Procedural history. We filed a claim for wrongful discharge under California law as well as sex discrimination. Defendant moves to dismiss on grounds of First Amendment. Plaintiff timely opposes, and defendant timely replied. Great, let's discuss the law. Under Rule 8.2 of the Federal Rules of Civil Procedure, a complaint must include a short and plain statement of a claim that shows that the pleader is entitled to relief. A complaint that fails to meet this standard may be dismissed pursuant to Rule 12. Dismissal under Rule 12 is proper when the complaint either lacks a cognizable legal theory or fails to allege sufficient facts to support the theory. So in other words, there is no law, or you have no facts to support your law, even under your telling, because it's all based on what you said. So there is no law, or you have no facts to support the law that does exist. That's 12b-6. To survive the motion, the plaintiff must allege enough facts to state a claim that's at least plausible. Great. A claim that has facial plausibility when plaintiff pleads factual content that allows the court to draw a reasonable inference defendant is liable for the misconduct. The plausibility standard is not akin to probability, but asks for more than a sheer possibility defendant acts unlawfully. Yes. So we are not asking for more probable than not, because that's what a civil claim ultimately is trying to get to. We're trying to get to more probable than not. That's the end goal, right? So it'd be a little bit weird for you to have to do that right at the start. So we don't have it more probable than not. So it's not about probable, it's about possible, or rather plausible, because also we don't tolerate like mere conjecture. We don't tolerate like, thin veneers. There needs to be a little bit there. How much there? If we're trying to get to 51%, how much do we need to make past the motion to dismiss? 10% maybe, right? 10% certainty, something like that. So if we have anything more that, anything that passes the laugh test would be fine. All right, that would be fine. Great. When ruling on the 12b6 motion, the court accepts factual allegations in the complaint as true and construes the pleadings in the light most favorable to the non-moving party. We accept everything you say as true. That is what we do in a motion to dismiss. The court is not required to accept as true allegations that contradict exhibits attached to the complaint. So if you provide us information that's contradictory, we don't have to accept contradictory information because that would be dumb. And we also don't have to accept allegations that are mere conclusions, unwarranted deductions, or unreasonable inferences. Right, we have to accept your facts, not your conclusions, and certainly not conclusions of law. Although a defendant may not ordinarily raise affirmative defenses as a basis to dismiss, generally speaking, that's true. But of course, there are a few exceptions. The Ninth Circuit, where we are, because this is California, recognizes an exception to this general rule where the defendant raises no disputed issue of fact. Okay, a complaint may be dismissed where the allegation of the complaint gives rise to an affirmative defense that clearly appears on the face of the pleading. So if you, in your pleading, basically allege facts that give rise to the defense, then that's okay. You can't introduce new facts in your response. You have to take their facts as given. But if you have a defense based on their facts, you can raise the defense. Makes sense? Dismissal is appropriate, however, only when a plaintiff pleads itself out of court. In other words, your own pleading does you in, or omitting all the ingredients of the impenetrable defense. So again, your own pleading does you in. Makes sense. When dismissal is appropriate, a court should grant leave to amend unless you can't possibly cure. So dismissal without prejudice unless there's no way you could possibly fix this. Okay, great. Discussion. California law protecting employees. Now, this, of course, is going to be driven by state level law, as would be true for any contract. By the way, contracts are a matter of state law. So, of course, you can do this in broad-based principles, but when you get into the specific state law will, of course, control. So California state-specific law is the matter here, and we have to look to the specific issues that are available at state law. So these may or may not apply in your own state. California law provides robust protections for employees' political activities. Under California law, employers may not make, adopt, or enforce any rule, regulation, or policy, either forbidding or preventing employees from engaging or participating in politics, or from becoming a candidate for public office, or controlling or directing or tending to control or direct the political activities or affiliations of employees. Now, that is written fairly broadly. Okay, California does, by state-specific law, okay, protect political affiliation as a protected class. This is not obviously a federal law thing. Federal law protects you for discrimination on the basis of sex, religion, race, that kind of stuff, right? But California, along with some other jurisdictions, provides a protection for political affiliation on top of this. However, despite the relatively broad wording of the statute, the relevant state law courts have radically construed this, or radically constricted this, I suppose would be more appropriate. So although it looks relatively broad on its face, not so much under the relevant state law. It protects like raw political affiliation, so Republican, Democrat, and it protects you going to like official party events, right? The official Republican Party events, but really not much more under the operative interpretations. So broad in writing, but the operative court decisions have constricted it much narrower than it appears. So that is sort of my thing that pops in the top of my head right away. Okay. California law further provides that no employee or no employer shall coerce or influence or attempt to coerce or influence his employees through or by means of threat of discharge or loss of employment to adopt or follow or refrain from adopting or following any particular course of line of political action or political activity. Again, broadly worded, the case law less so. Employees injured in this violation may sue for damages. Separately, under California law, provides that employers shall not discharge an employee or in any manner discriminate, retaliate, or take adverse action against an employee because the employee engaged in conduct delineated in this chapter. So it's a protected class. The nature of the protection, though, yeah, is where things get more interesting. Additionally, under California's Fair Employment and Housing Act, it provides that it's an unlawful employment practice for an employee to discharge or discriminate against an employee in compensation or terms of conditions, privileges of employment based on employee sex, which that would track with the federal law. That would track with the federal law. So you can't discriminate on the basis of sex, right? In any sort of way. You can, in terms of not just salary, but privileges of employment, which is pretty broad under the federal law. So this would include any kind of compensation of any variety. This would include being able to go to, I don't know, any sort of company event, any sort of company perk, right? Any sort of company benefit, anything that derives from your employment. The employer can't discriminate based on salary, perks, access to facilities, access to whatever, based on sex. That's illegal. So that does track with the federal law. That's fair enough as far as it goes. But of course, the trick is, of course, it has to be based on sex as opposed to based on something else, right? You have to discriminate against them because they're a woman or because they're black, as opposed to some other reason. That's the tricky part. Okay. Moving on. Let's see. Okay. Here, the defendants assume, without conceding, the plaintiff's complaint adequately states a claim for wrongful discharge motivated by political activity and for unlawful sex discrimination described above. Okay, well, that makes things a lot easier, right? If the defendants assume that they state a claim for wrongful discharge motivated by political activity and assume they state a claim for unlawful sex discrimination, if the defendant concedes that, then we suddenly don't have to get into those issues I just talked about, at least for the purposes of this motion, right? I was sort of teeing this up because I'm like, under the actual state law, the discrimination against political affiliation is much narrower than the statute and regulations would appear. Discrimination on the basis of sex has to be based on sex. But if defendants concede it for the purposes of the motion to dismiss, then I suddenly don't have to answer those questions anymore because they've conceded it. So that makes my life as a legal analyst much easier. Great. Moving on. Okay. Defendants assert, however, the claims are barred by the First Amendment. Yeah. No. I don't see how that works. No, that doesn't work. Yeah. No. Although defendants do not appear to contest the facial constitutionality of the California Labor Code, defendant contends that entities that do create speech products enjoy a right to make decisions about what they say in their own art and how to say it, including by selecting individuals who perform or otherwise create that art. Okay, this can get incredibly tricky, but let's discuss this in broader First Amendment principles. All right, it is lawful to discriminate on the basis of sex or race in so much as it furthers the First Amendment objective. And I say that with very amount of care, because the law prohibiting discrimination on the basis of sex, the law prohibiting discrimination on the basis of religion, the law prohibiting discrimination on the basis of race is a statute. And Constitution beats statute, right? Now, it's worth pointing out that in the statute itself, at least on the federal level, and of course, not necessarily state law, but on the federal level, discrimination on the basis of sex is lawful if it's for what's called a bona fide occupational qualification. That's a wonderful term, bona fide occupational qualification. So if it needs to be a woman, or if it needs to be a woman because of the nature of the occupation, then that would be lawful. An example of which might include, okay, you are a police force and you want to do strip searches. And, for everyone's benefit, you want to insist the person that does the strip search is of the same sex as the person getting strip searched, right? And so that would be the nature of a bona fide occupational qualification, right? We are not doing it just because we hate women or we hate men. We're doing it because of a business necessity. Okay, another example of which would also ironically perhaps include the waitresses of Hooters. Why are all the waitresses waitresses? Why aren't there any male waiters at Hooters? This is the exact reason why. Bona fide occupational qualification. Our entire purpose here is to titillate you, quite literally. And we need women to accomplish that objective. So you must be a woman, and this issue has been litigated, as you might expect. So this is not just me guessing. I know this because this issue has been litigated. So yes, you can make all the waitresses because, well, tits and ass, right? That is the thing we're going to do, okay? So that is the federal law. Federal law allows for discrimination on the basis of sex if it's a bona fide occupational qualification. Federal law does not, in the statute, however, allow for discrimination on the basis of race for any reason. So unlike the discrimination on the basis of sex, which by the statute allows for discrimination on bona fide occupational qualification, the federal law as it relates to race does not provide for any exemptions. There's no such thing as a bona fide occupational qualification when it comes to race. That, however, being the case, Constitution beats statute. Constitution beats statute. So First Amendment, right? So if you are doing an artistic work, then discrimination becomes lawful because it might be necessary for the purposes of the artistic work, right? You as an artist wish to cast Romeo and Juliet, and you'd like to do this the traditional way. Well, I suppose if you're doing it super traditional, both of them would be male. But either way, yeah, because in Shakespeare's time, there were only actors. So I suppose it depends how traditional you want to get. But either way, right? It's like you can have it be all male, you could have it be all female, you could have it be all white, you could have it be all black, and these might send different messages depending on the nature of the performance. So you can do that because it's in the nature of the artistic protection. So there is a narrow caveat for that, but of course it has to be in the nature of the First Amendment message that you're trying to distribute within the context of the medium. So you can require the actor to say certain words. You can require them to be a particular race because you're trying to send a particular message, but it has to be within the context of the artistic performance. And here the problem is arguably that Disney is going outside of that, right? It's not that we want it to be a woman or we want it to be a male for the nature of the art. We're upset not because she won't perform the lines the way we want her to. We're upset because of things outside of the context of the artistic work itself. We're upset with her because of her social media. We're not upset because she doesn't fulfill our artistic vision, which you already knew right away, by the way, because they hired her in the first place. And they also offered her this position in the first place. So it can't really be for the nature of the artistic work. It must be for some other reason. And so that's basically what they're talking about. Hopefully that all makes sense. Sorry to spend a little time on that, but it's a very nuanced area of law. So I wanted to try to give as much description as possible. Okay. Where were we? Okay. In these circumstances, defendants argue imposition of liability for wrongful discharge and sex discrimination would unconstitutionally burden defendants' right to protect their own speech from association with plaintiffs' high-profile, controversial speech. Yeah, I don't think that works. Not under the operative case law that I'm aware of. I don't think that works. But okay, let's see what they say. The First Amendment of the United States Constitution, which applies to states under the 14th Amendment, provides that Congress shall make no law abridging freedom of speech or of the press. The First Amendment's protections apply equally to non-criminal and criminal proceedings, including where a state attempts to impose liability through civil law. The guarantee of freedom of speech guards only against encroachment by the government and erects no shield against merely private conduct. So individuals can discriminate on the basis of First Amendment all they wish. But of course, it has to be within the confines of the First Amendment. And that's where we get into these wonderful boundary issues that I just talked about just now. Because if you are producing an artistic work, that is the First Amendment interest, the artistic work. But that is the nature of the First Amendment interest, the artistic work, right? So the very thing is also the nature of the limitation, because it's the boundary of the thing, because then you're getting into conduct rather than speech. That makes sense, hopefully. It's very nuanced and can be a little bit complicated. Okay. Let's see. The First Amendment protects not only against political and ideological speech, but speech occurring in entertainment as well. It surely does. Motion picture, program broadcast by radio and television, live entertainment, such as musical and dramatic works, fall within the First Amendment. No duh. You can put on your play. No duh, right? Further, that various forms of media are published and sold for profit does not prevent them from being a form of expression. You can do it for money too. That's fine. Cool. In addition to the First Amendment's explicit free speech guarantee, implicit in that right is to engage in activities protected by the First Amendment is a corresponding right to associate with others in pursuit of a wide range of political, social, economic, educational, religious, and cultural ends. And this gets into the fun thing about exactly what speech is, which gets complicated when you're doing things. I mean, speech is obviously speaking, right? But when you're doing other things, is that speech too? This also somewhat relates to, for example, Masterpiece Cake Shop, which we've discussed in the past, right? A gay couple comes into the bakery. They say they want a custom wedding cake. They wanted to display this custom message affirming their gay marriage. The baker says no, right? Okay, so can the baker do that or not? And that gets into the issue of, is this speech or is this conduct, right? Now, if the baker refused to sell a pre-made item, you'd have no problem, right? Because it's just a pre-made item, right? Off the shelf. Or even if they had to make it from scratch, if they had a book, right? They had some book, and here's like all the cakes I make, right? And they're like, okay, I'd like cake number 73. No, I won't make you cake number 73. Okay, then you're toast because it's in the book, because it's already on sale. But if it's custom made, right, and you're having to send a message, then that's Masterpiece Cake. This also was incidentally when it came to the internet, where this issue was finally decided in a cleaner fashion when it came to this issue, because we had a website and the issue about whether or not there could be certain statements on the website. That was where it finally got decided. Was that something 513 or 523 Creative, I believe was the name of that case, which was actually the case that actually got decided. Masterpiece Cake got punted because it was a little bit, it wasn't as clean, right? Because you have this physical article, the cake. So it isn't as clean. The case that finally got decided that reaffirmed the principle was much cleaner because it's a website. And so you didn't have this problem. So, but that's basically where we're trying to draw the line of delineation on that issue. Hopefully that all makes sense too. Great. Government actions that may unconstitutionally burden the association freedom may take many forms. A regulation that forces a group to accept members it does not desire is a clear example of the type of intrusion into the internal structure or affairs of an association that may burden that freedom of association. See, for example, the Boy Scouts, when that case was still being decided on this exact issue, right? So there's definitely a freedom of association argument in there as well. The Boy Scouts could not be forced in taking certain things. They ultimately decided to do so voluntarily many years later, which I think incidentally is a very smart move. We'll see how it pans out in the end, but they couldn't be forced to. That was what the Supreme Court said in Boy Scouts of America. Okay. A regulation that, okay. In Dale, for example, the Supreme Court held that a New Jersey public accommodation law, in a way that required the Boy Scouts to readmit as a member an assistant scoutmaster, Dale, who was a gay rights activist, who was open and honest about his sexual orientation violated the Boy Scouts' First Amendment freedom of association because it placed a significant burden on the Boy Scouts' desire not to promote homosexual conduct as a legitimate form of behavior. So these things can get incredibly complicated. Incredibly complicated. The right of association for expressive purposes, however, is not absolute, because then you get into the idea of conduct, right? So you can get into conduct that is not protected. When a facially viewpoint neutral law is narrowly tailored to serve a compelling governmental state interest, the government may be able to justify any derivative impact such as law on freedoms. In other words, strict scrutiny, because that's the test for strict scrutiny. Narrowly tailored, compelling. Oh, those are strict scrutiny words. So sure, if you can meet strict scrutiny, then you can infringe the First Amendment. But good effing luck getting your statute past strict scrutiny. Not gonna really happen. And it's really, really hard because, well, it's a big deal. Here, the defendants urged the court to read Dale together with Haley. In Haley, the Supreme Court held a state court order requiring private organizers of a Boston St. Patrick's Day parade to allow a group of marchers who wish to express their pride in their Irish heritage as being openly gay, lesbian, and bisexual to march in the parade carrying their own banners, violated the First Amendment because the order essentially required the private organized to alter the expressive conduct of their parade. Which, by the way, these decisions are kind of consistent. They're not in opposition, right? In both cases, the organizers were like, we don't like the speech. Because that was the argument, right? In Boy Scouts and in Haley. The Boy Scouts are like, we don't want gay scoutmasters because we don't support that and we think it taints our message. In Haley, the organizers of the St. Patrick's Day parade are like, we don't want the gay people in the parade because it doesn't support our message in our parade. Right? So either way, it's like, yes, the organizers have a right to discriminate on the basis of the message. So yes, that's generally speaking correct. Moving on. Defendants contend these two cases together establish that a state cannot force an employer to engage in expressive activity to express its message through speakers who, in the employer's view, would impair the employee's ability to convey its own preferred message. Okay, as an initial matter, neither Dale nor Haley arose in an employment context, which is also true because that comes with enhanced baggage, right? That comes with enhanced baggage because now you're regulating not only First Amendment, you're regulating a commercial endeavor, which comes with enhanced baggage. So because under First Amendment principles, because it might be commercial speech, for example, and if it's commercial speech, then maybe intermediate scrutiny applies. So things get a little bit trickier. Plus, in the nature of employment, we're also very, I suppose jealous is exactly the right word. We're jealous of the boundaries between speech and not speech because we want to make sure that the employer is only firing you for speech and no more. Incidentally, by the way, for what it's worth, during the 50s and 60s, there were many attempts by businesses to use First Amendment principles to prohibit the Civil Rights Act from being applied to their businesses. So a lot of this case law is also fairly old because we've been down this road before. There were Southern businesses, hotels or barbecue joints or whatever. It's like, we don't want to serve African Americans. We don't want to house African Americans. We don't want them to be our patrons. And we're going to say it's freedom of association, freedom of speech. And that didn't work. It's like, no, you're just a hotel. Your job is to let people stay there for the night. No, you're just a barbecue restaurant. Your job is to serve barbecue food. Right? So it's like, you don't really have a First Amendment message here, except barbecue is great and staying at hotels is awesome. right? So those are some of the boundaries we talk about. Thank you, Q, very much for the gift membership. And thank you very much, Tony, for the gift memberships as well. All right. By the way, if you have any questions, let me know and I will take your questions as soon as I finish this paragraph. Give you time to type. All right. The Supreme Court in Dale evaluated the scope of the freedom not to associate recognized in Roberts, including examination of whether a group is protected by the First Amendment's association right in the first instance. Hurley, in contrast, concerned the principle of autonomy to control one's own speech free from government interference. The court accordingly examines the framework set forth for each context, beginning with the right of freedom of association. Cool. Where's my tab so I can see what people are saying? All right. I think I accidentally just closed the tab when I was trying to remember what was playing audio. All right. No questions, it looks like. Okay, let's press on. Okay. Let's read some more. When organizers claim protection under the First Amendment expressive association right, a court must determine whether the group engages in expressive association. That's one of the keys. Is it an expressive association? Because there are non-expressive associations, such as, for example, your friendly barbecue joint. That's not expressive, except in so much as barbecue is awesome. Okay? Accordingly, the First Amendment's protection of expressive association is not reserved for advocacy groups. A group seeking such a protection must, by its associational choices, engage in some form of expression, whether it be public or private. So you don't necessarily have to be, a raw expressive group. Like, you don't necessarily have to be vociferous about it, but you do have to be expressive. You have to be organized for an expressive purpose, an expressive message. That is the nature of the organization, is to be expressive in its nature, as opposed to be non-expressive in its nature, hotels, barbecue joints, and so forth and so on. Okay. The court would then evaluate whether the challenged governmental action unconstitutionally infringes upon the organizational's expressive rights. Cool. A party's claim that the application of generally applicable law would infringe its rights of expression or association must be supported by a showing that compliance with the law would somehow inhibit its association. Okay. So even if you are an expressive group, you still can only discriminate in so much as it would go towards the core of your message. So if the message is, animals should not be abused, you can't just discriminate on the basis of black or white, because what does that have to do with whether or not animals should be abused? It has nothing to do with whether or not animals should be abused, right? You're an advocacy group. You're advocating that animal abuse is bad. Okay, what does that have to do? What does black or white have anything to do with it? What does man or woman have anything to do with it? Right? So that's where you go. That makes sense. Great. Moving on. In Dale, for example, the Supreme Court concluded that the Boy Scouts engaged in expressive activity because it sought to instill certain values in its youth members by having its adult leaders spend time with and instruct those members. Two of the values the Boy Scouts claimed to champion were values represented by the terms morally straight and clean. The Boy Scout represented that it teaches that homosexual conduct is not morally straight, and took the official position that avowed homosexuals were not to be Scout leaders. The Supreme Court concluded that enforcing New Jersey's anti-discrimination law and requiring the Boy Scouts to allow Dale, who was openly gay, to serve as an assistant scout message would have forced the organization to send a message contrary to its values. And obviously that's very, very nuanced, because, what exactly is the Boy Scouts gets to sort of the thing, right? What is the nature of the Boy Scouts is one of the fundamental questions in that case, because, well, what's the fundamental nature of a hotel? That's pretty easy, right? People come in, they pay you money, they stay for the night, they leave, end of transaction. What's the fundamental purpose of a barbecue restaurant? People come in, they pay you, you give them barbecue, they eat, they leave, end of transaction, right? What is the fundamental purpose of the Boy Scouts? Okay, well, that's a little bit more muddied. It's not super duper clean. And the Boy Scouts have always had values as part of its organizational structure, basically since the very beginning. So part of its purpose is in instilling these values. And that is part of its legitimate, bona fide, real purpose. So to the extent we're infringing on that purpose, we have a problem. And that's what the Supreme Court wrote about. Great. Okay. In contrast, in Roberts, the Supreme Court rejected United States JC's claim that requiring an organization to accept female members under a Minnesota anti-discrimination statute imposed any serious burden on the male members' freedom of association. There, although the national and local levels of the organization had taken public positions on a number of divisive issues, the JCs had failed to establish that admitting women as full-time voting members would impede the organization's ability to engage in those protected activities or discriminate on its preferred views. So the JCs didn't want to allow women to join. But in analyzing the case, it's like, how are women joining contrary to your message? And they weren't able to do it. Because it wasn't one of their messages. They have many messages, controversial messages to be sure, but none of them that would be impaired by it being a woman or being a man. So being a woman or being a man was irrelevant to those particular messages, and thus, as a consequence, the discrimination is unlawful because there's no First Amendment protection because you don't have a First Amendment interest in it. Okay. The Supreme Court further concluded that even if enforcement of an act causes some incidental abridgment of the JC's protected speech, that effect is no greater than necessary to accomplish the state's legitimate purpose. Here, although defendants indisputably engage in an expressive activity, including, but certainly not limited to, producing and disseminating the Mandalorian, they have failed to establish that they engage in an expressive association. And again, this is where gradating these lines becomes very challenging and very nuanced, because no one can dispute that Mandalorian is expressive. No one can dispute that it's sending a message. But the nature of the message of the work is not the same as the nature of the message of the association. In this context, they're not the same because of the nature of what Disney is. Or for other groups, right? Because they don't have any interest in association. And you know that, incidentally, because they hire men and women and black and white and gay and not. And so they don't in fact have any issue with those things because that's the nature of their behavior in the association. Okay. Says, who describes a legitimate purpose? Better way to put it Better way to put it rather than legitimate is whether or not it's real, as opposed to being contrived. So it's like, yeah, so you can always question whether or not someone really believes something, right? So that's always a factor because that's just a question of fact, whether or not someone really believes it or not. And that's just a question of fact. And then, of course, you can also pretend that you have an interest, but you don't really have it. And the way you know that is by looking at broader context. Like, is other behavior consistent with that? That'd be the same way you know about whether or not it's really believed or whether it's contrived. So when the hotel owner or the barbecue restaurant says, we don't have an interest in serving blacks. It's like, but why? And how does it inhibit you? How does it inhibit your message? And it's like, it doesn't really work. There's nothing legitimate that goes to the nature of it. So that's hopefully answer. The question about is whether or not it's real. The question is whether or not it's real or contrived, I suppose, is a better way of putting it rather than legitimate. All right. As an initial matter, unlike the Boy Scouts or the JCs, defendants are not a members-only nonprofit. Instead, defendants are for-profit who, as relevant to this lawsuit, employ actors such as plaintiffs, as well as administrative staff to create television roles and films. Speakers do not, however, of course, shed their First Amendment protection by employing the corporate form to disseminate their speech. But unlike Roberts or Dale, defendants have not identified any evidence in the complaint or otherwise to substantiate a claim that they employ public-facing actors for the purpose of promoting values of respect, decency, integrity, or inclusion. That's not why you employ them. You employ them because they're good actors and can do the work. Not for those purposes. Those might be side benefits, but that's not in the nature of why you hired them. So that makes sense, or at least could make sense. Accordingly, defendants' invocation of supposedly detrimental effects of plaintiff's mere presence as one of defendant's employees lacks a constitutional import. Further, even if defendants could demonstrate the employment of actors is a form of freedom of expression in the association, plaintiff has plausibly alleged that defendants terminated her employment to divert attention from criticism of defendants' business dealings and of the CEO, not to fortify defendants' supposed expressive association. When, as here, there are two alternate explanations, one advanced by defendant and one advanced by the plaintiff, both of which are plausible, plaintiff's complaint survives the motion to dismiss. Although defendants claim that the court must defer to defendants' interpretation of whether their message would be impaired by the association with respect to other speakers, this is not the proper standard at a motion to dismiss stage. Instead, plaintiff's complaint may be dismissed only where the defendant's plausible alternative explanation is so convincing that plaintiff's explanation is implausible. As defendants have not met the burden, dismissals based on purported association right is inappropriate. So they may ultimately win at the end. But here plaintiff has two plausible explanations, and we need further exploration to decide which is the correct one. And the factor which they influence things. It's all that. Yeah. Finally, as in Roberts, it's unclear at this stage, the litigation, whether defendants could establish that enforcement of California's anti-discrimination law imposes burdens on their associational rights beyond those necessary to accomplish the state's legitimate purpose. The relevant California Labor Code reinforces substantial public interest in protecting a fundamental right of employees to engage in political activity without interference or threat of retaliation from employers. I'm not sure, incidentally, that's the correct reading of the California law on this issue, but that might come up more in a motion for summary judgment or potentially appeal. So I'm not sure that that's a correct recitation of the law, but we're moving forward at least for the moment. Under California law, there is no doubt statutory protection for employees' political activity, particularly political speech, ensures to the public at large, rather than simply to an individual or proprietary interest of the employee or employer. Because of California state-specific law, to the extent the court is right, I have my doubts. As stated by the California Supreme Court, the freedom of an individual to participate in political activity is a fundamental principle of a decent democratic society and the premise upon our form of government. Plaintiff also brings suit under the Fair Housing Act, which represents a fundamental public policy decision regarding the need to protect and safeguard the right of all people to seek and hold employment, because the Housing Act also guarantees employment for some reason, because that's what California wrote. To prevail on these defenses that the expressive association right bars the claim, defendant must show that any impact on their claimed association cannot justify California's interest in eradicating sex-based discrimination and employer pressure on the employee political activity. The relevant law may be justified by regulations adopted to serve a compelling governmental state interest, unrelated to the suppression of ideas that cannot be achieved through means less significant. In other words, strict scrutiny, but good luck. At this stage, they've not made such a showing. They therefore deny the motion insofar as it argues defendants' expressive association right bars the claim. All right. Invoking the concept of speaker autonomy, as articulated by Hurley, defendants argue plaintiffs' claims are barred because, as entities engage in expressive communication, defendants may choose to exclude from their own communications other speakers who defendant believes would impair defendants' ability to convey their own preferred message. Specifically, defendants contend that if allowed to proceed, plaintiffs' lawsuit would unconstitutionally interfere with their control over the Mandalorian. In opposition, plaintiff contends that she did not make any effort to alter the message of the Mandalorian, and further objects that defendants do not explain how plaintiff's personal, off-the-job social media comments would affect defendants' speech, which is kind of fair as far as it goes because she's not trying to change the message of the thing. So that is fair as far as it goes. The court agrees with plaintiff that defendant's conclusory assertion of impairment do not suffice to establish the First Amendment claim, especially in light of the Ninth Circuit case law that dismissal is appropriate only where the plaintiff pleads itself out of court by admitting all the ingredients of an impenetrable defense. As stated previously, it's well established that television programs, such as The Mandalorian, qualify for First Amendment protection under the relevant case law, and plaintiff does not dispute the issue. The parties disagree, however, on whether under the First Amendment, defendant enjoys a right to control casting decisions such that plaintiff's anti-discrimination claims are barred. Defendants contend that the message here, the plaintiff, is part of the message, and plaintiff's lawsuit impermissibly impairs defendants' right to control the content of The Mandalorian. As an initial matter, defendants' argument focuses narrowly on their termination of plaintiff without addressing her allegations concerning defendants' pre- or post-termination conduct, much of which lacks any obvious expressive or artistic import. So all the things that they tried to get her to do, right, in relation to her social media, sort of betrays Disney here. So Disney, according to Gina, according to the plaintiff, right, put pressure on her to change, to alter her pronouns on social media, to send certain messages, to attend certain groups, to attend certain struggle sessions, and so forth and so on. But what does that have to do with The Mandalorian in a contained sense, right? Did they send her to acting classes? No. Did they send her to help her figure out how to deliver her lines better? Did she object to wearing a particular costume? Is that the issue? No. Disney's efforts go outside of the message of The Mandalorian. They go to private conduct not related to what is displayed on screen. So Disney somewhat betrays its purpose here in some of the things it's trying to do. As for the merits of the defense, courts outside the circuit have recognized a circumscribed right to make casting decisions free from anti-discrimination law in certain fact-specific circumstances. In the relevant case law, for example, two African-American men who aspired to be chosen for a titular role of a television show entitled The Bachelor sued the show's creator, alleging that the show engaged in intentional race discrimination when casting the role to prevent any exhibition of actual romance between non-whites or whites and people of color. The court finding plaintiffs sought to regulate the content of the shows, concluding the First Amendment barred the claim. So there, it goes to what is being displayed on the show. That's the line we're trying to draw. And this is why it gets very, very technical or very, very close. Because in that case, they're like, we can't put a black actor on screen because there would be interracial relationships. And that's not the message we're trying to display. But it's on the screen. The relationship would be on the screen. The romance would be on the screen. And so the person who you're hiring is unavoidably linked by the nature of who they are fundamentally to the message, because you can just look at it, right? You don't need to know anything about the people, right? Because it's just plainly on the screen. You don't need to know anything about the actors or who they are. You just simply can know that one is white and one is black, and therefore it is an interracial thing, an interracial romance. It's inherent. It's unavoidable. It has nothing to do with what they believe privately. It has everything to do with what they're portraying on the screen. And that is the line of delineation in the case law. Or at least that's what the court thinks is the line of delineation. Okay? The court found the plaintiffs in that case sought to regulate the content of the show, conclude the First Amendment barred the claims. Importantly, the Claybrooks complaint explicitly took issue with and sought to alter the messaging of the show by requiring it to alter its discrimination hiring practices. Yeah, there was no way to separate the two. We discriminated against you in hiring because it was necessary to discriminate against you based on what we were trying to portray on the screen. There was no way to separate the two. And so the First Amendment picks up because they're inexorably linked in this context. Cool. The court also characterized casting and resulting works of entertainment as inseparable, reasoning that any First Amendment protection for an end product must also apply to the casting product because they are inseparable. It's unavoidable. In Moore versus Hatston, concerned facts somewhat closer to plaintiff's claims. In that particular case, out of the Southern District of New York, a black woman hired as a member of a chorus in a Broadway production of Haydenstown brought suit for alleged racial discrimination and retaliation after she was terminated from her position. At the time the plaintiff joined the production, Hadestown had employed an all-black chorus with white lead performers. The producers of the show, sensitive to conveying a white savior story, decided to change the racial composition of the chorus to avoid such a connotation. Immediately after the producers announced the change, the plaintiff made 2 complaints regarding racial discrimination she experienced in the production. The plaintiff was then terminated from Hadestown and the role was filled by a white actress. Again, this gets into the message. The message. In this case, they changed the message, which is their prerogative. They changed their speech, which is their prerogative. They had previously had an all-black chorus and white lead actors. Okay, that was the message they wanted to send for whatever purpose they wanted to send it. Cool. And then they're like, we don't really like the optics of this. So we're going to change it so that the chorus is now multiracial. It's because that changes the message. But that's the key. It changes the message. It changes the message. That was our motivation, at least as the case developed, or as the case was decided. At the conclusion of the case, because we're referring to the decision from the Southern District of New York, at the conclusion of the case, we concluded that they were trying to change the message, which is their prerogative. You can change your speech at any time. And then you have to do different things to change your speech. And so we fired her because she was no longer suitable for the message, but it was inherent in the message. We didn't fire her for any reason other than we wanted to change the message, and it was necessary to that purpose. So there you go, right? There you go. And those are the lines of delineation, okay? All right. It's very tight. It's very tight. And this is why cases like Masterpiece Cake, for example, which was punted, were punted. Because you suddenly you're blurring the line. And anytime you want to figure out exactly where the line is, that's problematic in law. Because you're trying to separate two things. And that's really hard. Legally, it's really hard to separate concepts. It can be done. It has been done. But usually where it's been done over long, long periods of time. And then we have black letter law because it's been around so long, because we fought it out long, long ago. But those are kind of the exceptions to law, is where things are clean. And the more you try to get to the boundary, the more things get unclean. And so, yeah, it gets fun and complicated. But I think the court is asking the right questions. Interpreting the plaintiff complaint in Hadestown, the court concluded that Hadestown was making casting decisions with an eye towards how the racial composition of the cast affected the story on stage. That's the key. The racial decision was necessary to the story, at least the story they were trying to tell. That's the key. Accordingly, that court dismissed the plaintiff claim for racial discrimination. The court, however, did not apply First Amendment defense to plaintiff's claims for retaliation, reasoning there was no basis upon which to conclude plaintiff's alleged retaliatory discard was related in any way to the inherently expressive artistic decisions that were made with respect to the cast. Extending defendants' First Amendment rights to retaliation claims, the court reasoned would impermissibly enable defendant to terminate any employee who engaged in protected activity, such as complaining about work activity, under the auspices of a creative decision. So, yeah. So they didn't dismiss for retaliation. They didn't dismiss for First Amendment retaliation. Because in that context, the speech was outside of the performance. The speech was outside of the performance. That's the nature of the retaliation, is the speech outside the performance. And so, yeah, there you go, right? There you go. Within this circuit, one court has rejected a broad First Amendment claim to immunity over casting decisions in circumstances similar to Moore. In that case, Raoul, the creators of a soap opera, The Young and the Restless, argued that plaintiff's suit over refusal to rehire her after she advocated for more racially diverse casting was barred by the First Amendment. So the actress says you should hire more diverse people. Okay. The plaintiff in Rawwell, an actress who performed on the show for 2 decades, alleged that the officials decided not to hire her in retaliation for engaging in protected speech, not due to discrimination in the casting process. The court concluded the claims were unrelated to the vision and did not raise First Amendment concerns. Again, this is California-specific law, or New York-specific law, before you get way too excited, because those jurisdictions have law that protects political affiliations to varying degrees, but they do. So this is very much being driven by California-specific decisions, although I think the court is arguably wrong about how it's interpreting those decisions, but maybe it's enough to get past a motion to dismiss, and maybe it's an issue of summary judgment later. But, that's to defer that to a later time, because only once you really understand the facts completely, maybe can you really apply the law on this issue. So we'll see. But, all right. Here, in contrast to Claybrook and Moore, plaintiff's complaint does not take issue with the message or content of The Mandalorian. She's not trying to change the show. She does not allege, for example, that she was fired because defendant wished to have fewer female roles on the show, or defendant made an artistic choice to modify the show's cast to include only liberal-leaning actors. Instead, plaintiff contends defendant fired her in retaliation for off-the-job political speech after attempting to make her renounce those comments and re-educate her. To be sure, the First Amendment may place certain limitations on the remedy for the claims. In particular, although the law entitles employees to reinstatement, it is far from clear to this court that such a relief would be comport with the First Amendment. So, while typically if you're wrongfully terminated, you can force the employer to rehire you, that may not be appropriate in the First Amendment context. So you may not be entitled to that relief, but you may be entitled to some other relief, namely money, or injunctions against, defaming her or whatever, but maybe not rehiring. But yeah. This matter is distinct from liability. So whatever is true of the remedy is not the same thing as liability. So you may or may not be entitled to that remedy, but what remedies is not the issue for underlying liability. Defendant motion also misconstrues the proper framework for evaluating factual allegations within the complaint. Okay. Defendant repeatedly asked the court to disregard plaintiff's accounting of her conduct as not relevant, instead urging the court to defer to defendant's claim they viewed the speech as compromising their expression. On a motion to dismiss, however, courts construe the pleadings in the light most favorable to the non-moving party. Although defendants might, with a more developed factual record, be able to prevail on the First Amendment defense on some or all of the theories of termination-related liability, the complaint lacks allegations to support defendant's assertion that plaintiff's presence as a prominent actor on The Mandalorian interferes with the defendant's choice not to produce a show associated with beliefs. Indeed, the procedural posture of this case, as well as distinguished facts and issues, stands in stark contrast to other cases defendants cite in support of their claimed First Amendment defense. In a different case, it concerned the Boston Symphony Orchestra's decision to cancel a series of planned performances with actress Vanessa Redgrave after receiving calls from subscribers and other community members protesting Redgrave's support for the Palestinian Libertarian Organization. At conclusion of the jury trial, the jury awarded Redgrave $100,000 in consequential damages, but on the Boston Symphony Orchestra's motion for judgment notwithstanding the verdict, the district court held that Redgrave could not recover consequential damages due to First Amendment concerns. On appeal, in dicta, the First Amendment discussed at length the grave concern about the conflict of rights created by Redgrave's Massachusetts civil rights claim. Ultimately, however, the court resolved the issue on state law grounds, concluding that Massachusetts law did not give rise to a cause of action for refusing to perform an artistic work. Given many of the differences between Redgrave and this lawsuit, including in governing law and procedural posture, they had little pervasive value at this stage. So in that situation, they decided not to host the work at all. They decided they canceled the performance completely. And so that raises its own set of questions. And it also raises questions under state-specific law, as you look at the Massachusetts version of its civil rights law. And so the court, in looking at it, said that there is no cause of action by refusing to perform an artistic work, because that presumably gets too close into the First Amendment domain. So, fair enough. Hurley is similarly unhelpful for defendants. In Hurley, the parade organizers sought to prevent certain marchers from applying or appearing as parade units carrying its own banner, which would have affected the message conveyed in the private organizers. After a 4-day bench trial, the state court ruled that marchers were entitled to participate in the parade on the same terms and conditions as other participants, and this ruling was affirmed by the Supreme Judicial Court of Massachusetts. Due to the ruling's impact on expressive content of the public, however, the Supreme Court concluded that forcing organizers to accept a marcher's application would violate fundamental rule of protection under the First Amendment that the speaker has autonomy to choose the content of the message. And that, of course, gets into the same issue. It gets into the nature of the message. In this case, the parade itself, the TV show itself, the play itself, the symphonic performance itself. It gets into the performance, not having the performance at all, making casting choices for the nature of the performance, be it the people participating in the parade with respect to the performance that is the parade, because it sends a message. It sends a message. So the correct line of delineation is the work. Here, in contrast, plaintiff's complaint alleges that defendant terminated her from Mandalorian not to control the show's content, but rather as a form of retaliation for holding disfavored political views and for objecting to content she perceived as harassment. And that is arguably sort of the line of conclusion here in separating the two concepts. Defendant also cites Ninth Circuit cases for the proposition that employers may not be held liable for declining to express themselves through employees the organizations do not want to associate with their expressive message. Upon examination of the case, the court concludes the characterization is inaccurate. In Green, it is not an employment lawsuit, but a case arising under Oregon's public accommodation law. There, the plaintiff, who is a transgender woman, sought admission to Miss USA, a beauty pageant, contending the pageant's natural-born female requirement was an unlawful form of gender identity discrimination. On appeal, the Ninth Circuit concluded that the pageant, like the parade, was a blend of performance and visual expression entitled to First Amendment protection. The pageant is expressive, is the idea, because you're trying to impact the expression of the performance. You're trying to change the performance. You're trying to change the nature of who's on screen relating to the performance that is the pageant. Okay. In another similarity to Hurley, the court concluded that given the pageant's competitive and performative structure, it's clear that who competes and succeeds is how the pageant speaks. In light of the lack of daylight between the speaker and the speech, the Ninth Circuit concluded the plaintiff's suit impermissibly sought to change Miss USA's speech and affirm the trial court's grant of summary judgment. As discussed at length above, the court cannot conclude this based on this complaint. In McDermott versus Ampersand Publishing, the Ninth Circuit affirmed the trial court's denial of an injunctive relief that would have required a newspaper to reinstate 8 employees it discharged during a union dispute. Reasoning that these 8 employees were bound to affect what got published, the Ninth Circuit held that to the extent the publisher's choice of writer affects the expressive content of the paper, the First Amendment protects the choice. So in these particular contexts, these employees are contributing expressively to the newspaper, which isn't necessarily true of every employee at a newspaper. There are many employees who do not contribute expressively to the newspaper. People involved in just in the raw printing, the getting of supplies, the maintenance of the machines, and that kind of stuff, right? But these employees were in the creation of writing. And so the employer's like, well, their views are going to impermissibly impact their writing, and so we don't want them. And so you get into that issue, and that is just the issue. Yeah, some people just deliver the paper. Exactly. Some people are just janitors. Incidentally, by the way, this is the same as it applies in a religious context. When it comes to religious discrimination, First Amendment principles are the same. Okay, this gets into the clerical exception. Okay, this gets into the clerical exception. Again, under statute, there is no exception to discrimination on the basis of religion under statute. Unlike with sex, where there's the bona fide occupational qualification, there is no exception in the freedom of religion. However, of course, Constitution beats statute, and there is a constitutional right of freedom of religion. So the case law on such issues has delineated between the clerical and the non-clerical roles of a church. So, for example, there was a case involving, I forget the nature of the thing exactly, but there was a woman that, for whatever reason, the church did not want to hire to operate its soup kitchen. I forget the reason why. It was a religious reason. It wasn't not a real religious reason. So she's like, she doesn't have the right religious views, which was true. She didn't have the right religious views. But the court said, well, the soup kitchen is not religious in its nature. It's a soup kitchen, right? It is not clerical. So you can discriminate in terms of who the pastor is. You can discriminate in other sort of core roles like that, but you can't discriminate in roles that merely facilitate, because those are not central to the religious message. So same kind of idea in the clerical domain. And there's lots of case law on that, delineating the lines, as I'm sure you'd appreciate. Great. Finally, after the parties' hearing, defendant filed a notice of supplemental authority asserting that their position is supported by a recently decided case called Moody versus NetChoice. Moody kind of punted. Unlike Moody, however, which concerns social media platforms and also was a punt, plaintiff's lawsuit concerns a scripted television show, not a forum or curated compilation of speech originally created by others. The court does not dispute defendants' general right to control their expression, but Moody does not address the argument here that employers who create expressive content are immune from liability under state anti-discrimination law when they wish to terminate an employee involved in the creation of the content when it isn't related to the content. Thus, the court denies the motion insofar as it argues the right to control the speech that bars the claims. Fine. This is, in sum, defendants have failed to set forth the impenetrable defense, and it can go forward for the moment. Well, my friends, this is an incredible decision. This is an incredible decision because it is slicing it thin, my friend. It's slicing it thin because we're somewhere on the boundary lines. We're somewhere on the boundary lines. And this case is trying to slice it. And I think is making a very reasonable legal conclusion. But it's obviously capable of being disagreed with on a pure legal basis because the lines are blurry. And which side of the line are we on is blurry. But I think the court's analysis makes a lot of sense. Particularly, incidentally, because the court notes that Disney was trying to impact off-platform speech. And therefore it reveals that Disney's motivation was not in the performance. Disney's effort to send her to the Maoist struggle session shows that its concern was not in the nature of the performance, but merely in the nature of the employee's views, and that were not reflected on the screen. And so it slices it pretty thin because Gina Carano is still Gina Carano. And so the nature of her work comes in, the nature of her speech comes in, arguably by a watcher. But this is arguably also for under state specific law. So I question this decision. I question this decision under the strength of the California state specific law. Is my biggest critique with this decision. Because unfortunately, my understanding, and I'm not a California lawyer, but I've read a few California cases, my understanding is that the courts have fairly narrowly construed the protections in a very, very narrow way. So I'm not sure how much protection she really gets from the statute. But maybe we need to know more. And we can deal with that in a motion and summary judgment. I also wouldn't be surprised, incidentally, if this decision gets appealed to the Court of Appeals. Although I'm not sure, strictly speaking, you can, because it's not an injunction and it's not a final decision. So I'm not sure you can appeal it, but they're going to try, I would think. So we'll see. You know, all the rest of it. So that's pretty much the end of that story. So I hope you enjoyed this stream. I enjoyed it. It was a very interesting stream to be sure, a very interesting decision to be sure, and one that raises some very interesting First Amendment questions to be sure. But it also raises questions, incidentally, as to the relief she can get and sort of the damages that she can get, what she's entitled to. But that's another story for another time, so we'll see how it goes as far as it goes. So I hope you enjoyed this stream. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.